Please be seated. Next case on our calendar is McCalister versus School Board of Bay County, Florida. We'll hear from the appellant.
Please the court, I'm Martha Chumbler with Carlton Fields Law Firm, here representing the superintendent of the schools for Bay County, Florida. With me at council table is my partner, Christine Davis, as well as Joy Frank, the attorney for the Florida School Superintendents Association. I'd like to reserve 5 minutes for rebuttal. Your Honor, this case is about a school board that has significantly overstepped its authority and has usurped powers that are delegated to school superintendents. Now, let me first address an issue this court itself has raised, and that's mootness. This case is not moot. The general rule of mootness is that a case becomes moot only if circumstances have changed in such a way that it leaves the court without any authority to grant effective relief to the parties. That simply is not true here. Mr. Bollinger has currently retired from the Bay County schools. However, under Florida statutes 120.0191, 0191, those restrictions only require that after he retires, he cannot simultaneously receive both the salary from his former employer and the retirement benefits. So as of today, he could go back as an employee of the Bay County School District. He merely would have to suspend receipt of his retirement benefits. Come June of 2008, he can actually receive both his retirement benefits and the salary from the Bay County School District.
Well, help me here, and I'm jumping ahead, on the remedy that we can grant, or, the effect.
Yes, sir.
If we find that they did have good cause to reject the transfer, and just for example, we kind of split the baby and say this, they didn't have the statutory authority to say that he's there till 2009. What would the remedy be? I mean, where would we be? He's retired from the school board. They, later on, I guess, which is part of our record, they did in fact agree with Mr. McCalister, secondary order. So where are we in this case?
Your Honor, if I understand your question correctly, you're asking is if you were to strip from the final order all those extra things that they added beyond what was in the recommended order, and you were simply to order that the recommended order stand as is, and so we're left with just the good cause issue, whether that issue itself, that discrete issue, would be moot. And one of the exceptions to the mootness issue is where you've got an issue that it might be moot technically between the parties that are here present today, but it's an issue of great public importance and involves public officials in the performance of their official duties. And certainly that good cause issue is one that arises in every school district in the state every year. It's going to rise over and over and over again. So I believe it falls within that category.
Normally the school board's not siding with the employee, though. That's a very unusual circumstance.
Most of the case law, you're correct. And in most of the case law, you've got a school board that has rejected a school superintendent, and the employee is siding with the superintendent. In this case, you've got an employee who was himself not pleased with the recommendation. But that's irrelevant. The statute doesn't make any reference to whether or not the employee always has the opportunity to say, no, I choose not to accept that position, and I choose not to be employed by the school district anymore. But the employee's preference as to where he is employed, where he's placed within the district, is not addressed in the statute at all. He's given no authority for that. It's the superintendent, and this court has said in the Green decision very clearly that in order for a school superintendent to be able to perform the duties that have been assigned to him, he must have the authority to control school personnel. And a very essential part, this court has said an essential part of that duty is the ability of the school superintendent to determine where within the district personnel should be placed and when they should be transferred.
Okay, well, help me here, because, I can read this order to say Mr. Bollinger was doing a good job as, principal of Bay High. We have all these things saying that he's doing a good job.
Yes, sir.
Mr. McCalister got upset with him. And, I'm going to characterize this and just take it as, kind of reading the order, that Mr. McCalister got in a snit over something that Mr. Bollinger did. If the school board actually did make those findings, isn't that good cause? I mean, they said that Mr. Bollinger is doing a wonderful job. This is too close to the next school year. why isn't that good cause for
Well,
rejecting the recommendation?
Let me point out a couple things to you. First off, no one disputed that Mr. Bollinger would not have been a fine principal for the position to which the superintendent recommended him, principal of Jenks Middle School. No dispute. Everyone agreed he would have been a fine principal there. All of the case law refers to whether the person nominated is qualified, morally or professionally, for the position to which they are recommended. Everyone agrees
Because
he
that's
was,
the
he was
usual, I mean,
qualified
this
for
is,
that.
because that's the usual circumstance.
Right.
You have somebody being recommended by the,
What the school board did not have before them, because they didn't give the superintendent the opportunity to make the recommendation, was who he would have recommended for the position of Bay High School and what the qualification, credentials, and moral ability of that individual was.
Are you saying the school board's authority is only to look at where an employee is being placed, not where he's being kept? I mean,
That's correct. And the school board has said, even within that, the decisions have said that even within that parameter, what they have to look at is the professional and moral qualifications.
so all the factors about it had improved, it was cleaned up, all that stuff is really totally irrelevant on your position.
That's correct. And I think,
And what about the promises? I mean, the implied, you're going to stay here if you agree to this when he was first transferred to Bay High.
well, to get to that, you have to get to whether or not, if you're determining whether there's a contract, clearly
no,
the school
forget
board.
about it being a contract.
If it's just an agreement.
Forget about it being a contract.
Okay.
Say it's a promise or something that was kind of told to this man. Can the school board consider that as a factor? Forget about it being a contract. I mean,
No, Your Honor, I do not think that they can. And it's in the same for any employee position. An employer hires someone for a position. A year goes by, and that employer decides, you know what, that isn't the best place. That is not the best position for that employee. A better place for that employee, a better fit for that employee, in my mind, as the CEO of this organization, is in another place. And that's exactly what happened here. That's exactly the role of the
I
superintendent.
understand your argument. I mean, there are other factors that might override that. But isn't that a consideration that the policymakers can look at? We don't want our superintendent or our CEO or city manager, I mean, it's kind of the relationship. We don't want him going out telling people, well, I'm going to keep you there for 4 years, because that's going to hurt morale in the school system. Isn't that something, a proper consideration for the school board?
No, Your Honor, it's not. And if you look at the case law that's been in this state, Supreme Court decision of Cherry is just an example in which the court said that the nomination of a superintendent becomes final unless...
Where do we relegate that consideration? To the voters the next time the superintendent runs?
Exactly, Your Honor. If the voters do not like the decision of the superintendent, Bay County has an elected superintendent, and they can choose not to elect him.
I suppose if they hadn't appointed the superintendent, they couldn't change the employee per se, but they could fire the superintendent.
Exactly.
And then
That's
maybe
correct.
the new superintendent would catch on to their preference.
That's correct. And let me point out something to you very important in the statute that describes the responsibilities of the school board and the superintendent. Section 1012.22, paren 1, assigns to the superintendent the duty to make a number of different kinds of recommendations to the school board. He has to recommend the types of positions that will be created, the qualifications of those positions, and the specific individuals to fill those positions. 3 different recommendations he makes to the school board. Only one of those, only as to the last of those, does the good cause standard apply. Now, in all instances, the school board, as an agency subject to Chapter 120, cannot act arbitrarily. So the arbitrary standard applies to all 3 of those. They cannot reject any of those recommendations in an arbitrary manner. Only as to the specific individuals for certain positions must they add the added standard, the heightened standard of good cause, which the courts of this state have uniformly described as relating to the moral and professional qualifications. In some cases, they qualify it or refer to it as
How
the
about
credentials.
if they said this guy had the greatest morals and the greatest professional standards, and we need somebody like that at Bay High?
The superintendent, whose role it is, according to this court, to determine the best position, felt the best place for that individual was at Jenks High.
Well, I mean, actually, what you're saying, I mean, it's not, you keep using the word best, but technically we wouldn't use that word because it's not a comparison between 2 positions. All they can evaluate, your argument is whether or not he's appropriate for that position, not whether or not he would be better in some other position.
But, Your Honor, that's not their role. It's not their
No, but I
role.
mean, that's your argument, is that only the superintendent, but all they can say is yes or no to the superintendent's recommendation.
That's correct.
They can't say, you know, he'd be fine there, but he'd be better over here. That's not their role, is what you're
That's
saying.
correct. That is the superintendent's
And
role.
let me understand your argument. Is your argument here that they can never get into the decision to keep somebody at a spot? I think you said that earlier. Or is your argument that they did not have the facts available to them in this case to override his decision?
It's actually both, Your Honor. Our primary argument is that their decision of who they thought was better for Bay High is never appropriate. Wouldn't have mattered whether they had the facts or not. It's never appropriate. But because it doesn't relate to the moral professional qualifications of that person for the position to which they're nominated. Secondly, even if it were, in this case, there was not competent substantial evidence to have supported that finding. So it's twofold. Our primary argument is they couldn't have done it anyway. Our secondary argument is even if they could have, the evidence is not here in this case. The findings of fact are not here in this case.
So what's the school board do? I mean, you know, they walk around the school, they like the way it's going. I mean,
The school board always has the ability to define, if they felt like there were particular credentials needed for Bay High School, they have the authority to adopt those qualifications. They can change their policy to say, for Bay High School, the qualifications for the person who's going to be principal here are A, B, C, D, E, F, G, whatever they think is appropriate. That is their authority. They did not do that here. Instead, they tried to second-guess the role of the superintendent. They usurped his authority, which is to determine where the best place is within the school district for the benefit of the entire school district of Mr. Bollinger, of this particular individual. That they cannot do. Very clear from all case law. And, Your Honor, quickly, we've skipped over to the good cause issue, but let me just briefly...
Let me go back to the remedy here, because I think I understood you to say, well, we really don't have a remedy if we find the 4-year promise of the years in the future was not right. That if we determine that there was good cause here, there really is not a remedy.
I think that...
And I guess I got to ask you at this point, if the decision came down and said, you know, pretty much what I just said, and didn't specifically list a remedy, and just said we're remanding to the school board for further consideration, are we creating havoc in Bay County?
Just as if you affirm this decision, you're creating havoc
Okay,
in Bay
if we
County.
affirm a portion, okay, or even affirm the whole thing, but affirm, okay. It seems to me that if we affirm the portion saying he couldn't be transferred until 2009, I mean, arguably he's going to be principal Bay High. I don't know.
That's correct, Your Honor.
Okay, but if we just affirm the portion saying that they had good cause to reject the transfer.
Which I take to be if you affirm simply or directed them to strip from the final order all but what was in the recommended order, then as I
And then we just say
indicated,
we remand to the school board for further proceedings. Are we creating a
if you
fight down there?
If you remanded to the school board with the direction that they strip from the final order everything but what was in the recommended order, as to these particular parties and this particular set of circumstances, it would be moot. I concede that because
Could Mr. Bollinger make the argument at that point, well, if the transfer was not valid, therefore I should be principal Bay High?
No, well, you're talking about a contract. If I understood you correctly,
No, forget about the contract. I'm just saying if the order or the reverse, if we say there was grounds for the school board to reject the transfer, and therefore the transfer was not valid, where does that put us?
Well, that good cause determination related to the 2005-2006 school year.
Only that
which is
year
now
and
over.
anything in the
Just
future.
that 1 year. That's why I say as to these parties, that's moot. However, there is the exception from the mootness doctrine that if it's an issue that relates to public officials and therefore it's one that this court should retain jurisdiction for that purpose, because it will come up just not in Bay High School, but every school district throughout the state.
Let me ask you an
And I'm
elementary...
well into my rebuttal time.
We'll give you additional couple minutes.
Thank
Let
you.
me ask you an elementary question about what the superintendent can and cannot do. If the superintendent, and as I understand it, in this case, the recommendation was that he be the principal of a different school.
Yes, sir.
Which would necessitate his being moved from the high school to the new school.
Yes, sir.
If you reject that recommendation that he go to the new school, does that necessarily leave him at Bay High School?
Well, that was the practical effect of the way this unfolded, Your Honor, because it was done in a bifurcated way with a recommendation in May to the school board that administrators be rehired as administrators, principals, so on. And that recommendation that Mr. Bollinger be retained as administrator was made and was agreed to by the school board. Then a month later, the recommendation was made that he be transferred, and I think the transferred was used to Jenks High School. So the practical effect with the denial of that recommendation was that he remained at Bay High School.
If they had
Okay, that's because of the circumstances
Yes,
here.
that's because of the circumstances.
If they had made the recommendation that he be assigned, and they had turned down that recommendation, does that mean he would basically be an administrator with no assignment?
If the facts had played out in a different way, if in May he had simply not recommended Mr. Bollinger for assignment, we may not have been here today. But that's not the way the facts unfurled. And if I have any time left, I'd like some rebuttal.
Good morning. My name is Franklin Harrison, and I represent the school board. I'm here with Robert Fleming from my office. Major Harding is here representing the Florida School Boards Association, and Mary Aspros is here representing the intervenor, Larry Bollinger. I know you met the superintendent at the coffee break. The school board is not here. It's not because they're not interested. They've got 10 expulsion hearings they're handling this morning in Panama City. Business must go on. This case is not a case of a school board gone wild in their relationship with the superintendent, nor is it a power play by the school board in a struggle with the superintendent. It is not that at all. What it is the school board exercised its constitutional and statutory authority right out of the Constitution that says they have the ability or the responsibility to operate, control, and supervise all free public education in the school district.
Okay,
And,
would you agree?
Yes, sir.
That the statutory framework seems to indicate that the superintendent of schools each year has the opportunity to assign people or to recommend people for various administrative positions?
Well, it's a little more complicated than that, Your Honor. He has the ability at any time to recommend a transfer of an employee that's under contract. He has the ability statutorily.
Okay, I'm sorry. Go ahead. Finish your
Statutorily, he is required to renominate people once a year by statute, unless they are under a extended year contract, which there is authority by statute to go up to 3 years on a contract with administrators. In Bay County, they do 1-year contracts for administrators. So there's yes and no to your question.
Okay.
All right, is there any authority for the school board in this case to effectively grant Mr. Bollinger a 4-year contract?
The school board did. I don't think the school board granted him a 4-year contract. What they did is they went in, and as part of their good cause determination, that there was an agreement that one of the board members, it was talked about at the board members, and the hearing officer found that there was an agreement for him to stay there during his drop period. That was the inducement to get him to move over to the high school.
Doesn't that contravene statutory authority, though, that you can't have an appointment to a position that exceeds 3 years?
Actually, they only did it for 2 years. They did it for the 2000. The order said it was for the 2007, 2008, 2008, 2009 school year. It was only 2 years. By the time we got to a hearing, there was only 2 years left in what the original agreement was for 4 years, so they only said for 2 years and not 4 years, and did not go beyond that.
Well, under your argument, they could have done 4, right? Under your position, they could have done 4.
I think so.
They could have done 10, 15. They could have said Mr. Bollinger is the superintendent of the principal of Bay County High for the rest of his career, no matter how long his career was under your authority.
Well, I think it would fly in the face of common sense, but I don't think that would happen. But I think that the period of time, obviously this was a school that was in a lot of serious trouble. There's no question about that. We're looking for somebody handpicked by the superintendent to come in and turn that school around. And
of course, all of that seems to be kind of irrelevant, doesn't it, as far as what the authority of the school board is with respect to extending the term of his employment at that school?
I mean,
not
it
sure
doesn't
I
matter whether the
understand
school
your
was a good school or bad school or whatever, as far as this contract arrangement is concerned, is it?
No, sir, I don't agree. The reason I don't is because, I mean, there's great responsibility on the school board to operate the schools. I mean, they're grading our schools. We have school choice. People move around. And this was a school that was a problem school. They had put a lot of money in this school. They'd done everything they could figure out to do except change the principal out.
What if he did in fact promise him you could stay there for 4 years, and he turned out to be a mediocre principal? Not awful enough to fire, but not very good for Bay High. And the superintendent says, well, this guy's not doing very well here. I'm going to recommend him for the junior high school. Could the school board have been bound to keep him at Bay High, even if he was mediocre?
I think that the school board could look at it under the circumstances as you saw 2 years down the road or whenever they were, and make a decision given a reason coming from the superintendent as to why he is proposing
So
what's
that's what I'm
being
saying. If
done.
the superintendent had a reason, he could transfer him to another school in spite of this alleged contract, right?
With the consent of the school board. The statute says that when you want to reassign or transfer an administrator, you make a recommendation to the school board, and the school board makes a decision.
That's what I'm saying. The statute seems to contemplate that the superintendent has the right, as the manager of the school system, every year to make a recommendation concerning where this person should be. The order of the school board, the final order, seems to say, he's stuck there. I don't care how you think he's doing. Only if you can find out that he's violated a morals clause or whatever, can you move him. I'm having trouble finding that provision is statutorily authorized.
Well, but he's there because of the actions of the superintendent, and he's there for the period of time because of the actions of the superintendent. I mean, Judge Hood, in her recommended order, found that there was that agreement.
But Judge Hood did what the statute seems to contemplate. She made a finding to determine whether there was good cause or not.
Yes, sir.
She did not order the fact saying, Mr. Superintendent, you cannot recommend him leaving that school again for the next couple of years.
No, sir. That's the school board took that action in amending her final order. That is absolutely right. Now, in going further.
Well, help me.
Yes, sir.
Help me. I'm sorry, and I'm
okay,
sorry for interrupting, but it's our time, and I want to get questions that I have, Al.
Yes, sir. I'm here to answer them.
Okay. If we find, the question I threw the other side, split the apple, find the school board had good cause, but they did not have the right to, extend it for, years into the future,
Yes, sir.
where would that put us as far as everybody's legal rights in this case?
Well, I think that it would put the school board in the position of finding that the basis that they found good cause is correct, and they did the right thing in finding good cause. I think it would find Mr. Bollinger without a job in Bay County.
Okay. You don't think Mr. Bollinger can make any claims to a job as a result of that order? As a result,
Not if you reverse that portion of it. I don't see how you could. I mean, that's right. I do not.
I was intrigued by Judge Wolf's question. I mean, if the promise, hey, Bay County, Bay High is really in trouble. We need you. You're the man. Come on over. We'll leave you there for the rest of the time you're employed, the rest of your drop period. And he gets over there, and gosh, it just didn't work out the way the superintendent had hoped. He was a little more mediocre, perhaps. I mean, the personality, whatever, it didn't click. And it would seem as though if that's a good cause to not transfer him, then he's stuck there, and you've taken. I mean, if that's good cause, it's good cause. And just oral promise is now a binding contract on the superintendent and the school board. Because the superintendent encourages an employee. I mean,
I think you may be right in that instance. I mean, I think that we enter an order saying that you're stopped from moving him from that school.
So we have a
and then
D
he
school.
tries to move him, and we agree with it as a school board. He may have a cause of action. Yes, sir. I'm a third-party beneficiary of what you have done.
So we have a D school, and the superintendent's trying to respond to a D school and trying different things, but as soon as one doesn't work, he's stuck.
Yes, sir, but
Because an implied part of that, I would think, would be, I think you're the guy, and you can stay there as long as I continue to think you're the guy. I mean, and of course, the burden is not on the superintendent to come to the school board with a reason, is it? I mean, he comes and says, this is my transfer recommendation. Obviously, he can't do it arbitrarily or capricious, but the burden is on the school board to come up with good cause to say, no, it's not up to the superintendent to come up with good cause. I mean, obviously, he has to persuade the school board.
that is correct. That is absolutely correct. The school board has got to come up with a good cause as to why they're not going to accept his recommendation.
So the burden is on the school board.
The burden is on the school board to make that decision, yes, sir, and to come
And so if
forth
this
with
contract
facts on
is,
that.
if this oral promise is not good cause, then it would be reversed, correct?
If the oral promise is not good cause, standing alone all by itself, if that's not a good cause, then it would be reversed, yes, sir.
Okay, well, excuse me, I need to understand your answer to Judge Hawks.
Yes, sir.
If all we do is take away the promise, does the school board still have good cause to reject the transfer?
Absolutely, without question, Your Honor.
Okay, that's what I misunderstood your answer, Judge.
The good cause is the effect that it would have on Bayhigh by moving him from Bayhigh. It's clear in the Sperling decision that the school board has the right to make a decision that is not lawful, for a lawful, rational, non-arbitrary, non-statutory reason. And that's exactly what they did. Judge Hood laid out all of the reasoning, all of the testimony, all of the things that the school board went through as to the reasons for not moving him from Bayhigh. Bayhigh had gone from a D to a C. The attitude of the students, the faculty, the community, the grades were much better. The physical grounds, everything was going good. And then the superintendent walks in and said, I'm going to move him. No reason, no nothing. And that, the Judge Hood found, was good cause. And that's what the Sperling decision says. It is not, I take exception with the appellant's counsel, it is not on the moral and professional. That is not the only standard anymore. That was a Supreme Court decision that was made before the Constitution was actually changed. The Constitution used to say that the school board had the right to supervise the school district. Now it says they have the right to operate, control, and supervise the school district. And the Sperling decision is a more recent decision, and it talks about, it says that the quotes from the Von Stevens, straightening it out, because in Von Stevens it talked about the nomination could be turned down on moral and professional reasons only. And they clarified and said, that's not what we meant. We said that Von Stevens does not attempt to define good cause within any boundary.
And are we looking at where the person is or where the person is going? I mean,
I don't think it matters.
So
there's not a case anywhere that I can find. The statute says that we can turn down a nomination for good cause. It doesn't say you can turn down the nomination for good cause at the school he's going to. It just says you can turn down the nomination for good cause. And there's not a case anywhere that says otherwise.
Let me change gears with you.
Surely.
I want to make sure I understand your position. Did Mr. McCalister have the right to bind the school board to a 3-year contract?
No, sir.
So it's only the school board. So there could
That's
not
correct.
have been a contract at the time that Mr. McCalister and Mr. Bollinger talked.
That is correct. But you've got to understand, and there's some cases that have been cited, but is that there's a reasonable expectation of Mr. Bollinger that was going to be fine. He had been
and I'm not sure.
Excuse me.
And I'm sorry for interrupting,
That's right. No,
but I'm trying to get this in my mind. I proffered at the beginning that was a consideration the school board could take into account without a contract being signed. Is that correct?
Yes, sir. And that's what Mrs. Rowan spoke about at the school board meeting as a school board member. That's what she said.
So the decision of the hearing officer here was not that there was a bonding contract on the school board, because I just looked at
the findings of fact made by
number 17,
the
that
hearing
there was
officer.
an agreement between the two of them, but that would not constitute a bonding contract.
That's correct.
Okay.
But understand, and some of the cases talked about the reasonable expectation. The superintendent, Mr. Bollinger had been superintendent before. He'd sat in that position. He'd been an administrator in the district forever. The school board never has turned down a recommendation for a principalship in Bay County. He knew that if he had the word of the superintendent, assuming that would hold, that he was going to be there for you.
The other side of that is he would know it couldn't be a bonding contract as well, because he was already in that position and knew he couldn't enter into bonding contract.
Yes, sir, absolutely, and he knew that also. There's no question about that.
Clarify something for me in this
Yes, sir, Your
record.
Honor.
Had there not been a prior administrative action by the board in, I think Ms. Put had reassigning all administrative positions for the forthcoming year.
Yes, sir.
And that this then was a transfer. Had this recommendation been made before that action was taken, I assume that those reappointments were pursuant to a recommendation by the superintendent.
Yes, sir.
Blanket recommendation. Before he makes that recommendation, if he comes before the school board and recommends a transfer of this particular individual to the junior high school, what position is the individual in then if that recommendation is changed and he never makes a recommendation for the reappointment to the high school position?
Timing is everything, Your Honor. If the superintendent had come in before the time for him to make his recommendations and had said, I want to transfer Mr. Bollinger to the middle school, then the school board would be in the same position to make the same decision that they made today. Unfortunately for Mr. Bollinger, though, 2 weeks later, if the superintendent came along and said, all right, I'm doing the reappointments for next year because Mr. Bollinger only has a 1-year contract, forgetting the 4-year contract just in ordinary terms, then I'm sure Mr. Bollinger's name would not be on the list. And if the name's not on the list, the school board can't consider it. It has to come with a recommendation from the school board.
So had his name not been on the list for the reappointments, then he would not have been the principal at Bay High School. Is that correct?
No, sir. If he had come with the transfer either before or after those recommendations, the circumstances would still be the same.
I'm trying to understand, he only had a 1-year appointment. Is that
1-year
correct?
contract, that's correct, Your Honor.
And at the end of that year, they got the upcoming year, he is not recommended for reappointment
As an
by the
administrator.
superintendent.
That's correct.
What's the status of the principalship at Bay High School?
Exactly as it is under this order, because what would have happened, whether it's before or after that date, the school board could have done the same thing that they did, had the same administrative hearing with the same.
They could have inserted him in the administrative order and reappointed him without the recommendation of the superintendent?
Well, what happened in this instance, I think that they could have, yes, sir. I think that they could have under the basis of the way Judge Hood found this order.
Well, they can make an appointment to a principalship without a recommendation from the superintendent.
Well, the superintendent, was he going to, it's illogical, Your Honor, but you're not going to transfer somebody for a month. This was the end of the school year. This was right at the end of the school year when all this occurred.
Did they have to do something with Mr.
Just a
Bollinger?
year, less than a year, actually.
I think the question is, did they have to do something with Mr. Bollinger? What if he'd been left off the list?
Yeah, in May, when they made these are the people that we want to reappoint as administrators, it's a whole list, except Mr. Bollinger's name is not on it. Then what happens? Mr. Bollinger's without a job, isn't he?
Yes, sir.
And there's nothing the school board could have done about that.
Yes,
Well,
sir.
that's my
I would agree
question.
with that. I'm sorry.
Before the general administrative reappointment, if that list had come without Mr. Bollinger on it,
There's not a thing they could have done.
Okay, that's
But
good.
I
That
just
seems
understood your question, Your Honor. I thought you said if they came with a transfer before the nomination. But if everything just went along fine and here came the nominations and Mr. Bollinger's not on the list, I don't think the school board can act without a recommendation.
Okay, then that seems to go to their position that the school board cannot push somebody for a particular position. That seems to be almost a concession that you just made.
No.
Because it's their
But
position.
you've got to look
No,
at-
well, no, I'm listening very closely.
I know you are. But you've got to look at you've got to look at the facts. I mean, I've got to argue based on the facts of this case. And the facts of this case was that there was a reassignment of a principal who had been given a one-year contract at Bay High. That's where we were.
Okay, but basically you said Mr. McCalister could have done what he intended to do here. He just did it the wrong way.
Yes, sir.
So,
He did it the wrong way.
so
Absolutely.
let's assume that after this record is made and you're up here, the next year comes along, he spent the year at Bay High School, and the list of reappointments comes up, and his name is not on it.
Yes, sir.
And you've got an order that you've signed that says he's in there for 4 years. Where
Well,
is he?
I guess we'd be going to circuit court.
I guess, it seems to me that if the superintendent doesn't have to put his name on the list for the administrative reassignment, then that just says that this verbal contract is really nothing more than, in sales, a puffing, or, I mean, it's nothing more but encouragement. It has no binding legal effect. The superintendent had no authority to commit to that. He knew or should have known that the superintendent had no authority. Obviously, the superintendent's going to act in good faith, and he's going to act in good faith and reliance. But if that contract is gone, then the whole thing of him staying at Bay County seems to be gone. Bay High seems to be gone.
The most significant matter in this case is not that contract. The most significant matter in this case
Is the things at Bay High were going well.
and the definition of what good cause is. That is by far the most significant issue.
And if the school board decides C is great improvement, but the superintendent was hoping for a B, that wouldn't matter. In other words, they talked a lot about how they went into Bay High, it was cleaned up, the faculty was happy, the students were happy, went from a D to a C. I mean, maybe the superintendent had visioned a B for that school. He wanted it to become a B school, and he thought that was obtainable.
Who knows? No, that's true. I don't know. There was no reason given, nor was there a replacement. And it was, end of June, school getting ready to start, all of those other reasons.
What about if this middle school that he was going to was a D school and the superintendent wanted that brought up to a C? And he thought, Bollinger's my man. He can get that up to a C too.
It'd been nice if somebody had said that.
I mean, does he have to say that?
No. But, it's already been mentioned about an elected versus an appointed superintendent. Half the school districts in Florida hire their superintendent. This wouldn't happen but once. But once you go to an elected superintendent, what you use the standard that is here, what it does is it says elected superintendents, the sky is not falling down in, like you say, your Chicken Little approach. What happens is you are forced to work closer with your school board in making these decisions to work on these schools. And I submit to you that's a good thing.
Well, counsel, do you agree then that the effect of the school board's action in this case was to bind the superintendent to place the name of Mr. Bollinger on the list in succeeding years for reappointment to the administrative position?
Yes, sir. That's our position.
And the school board has that authority under the statute?
I think the school board
to
has
require
that.
the superintendent to reappoint a specific individual.
I think that based upon the circumstances of this case and the findings of Judge Hood, I think they do. I've gone way beyond the time, and I apologize. I was going to add.
Judge, we're trying to wear you out, counsel.
That's okay, Judge. I got to go back to the school board meeting.
Yeah, we're
Major
kind of
Harding
slow.
I was trying to reserve, but we just kept on 2 minutes or 1 minute for him to speak on the constitutional issue, which of course is very important. Well, if I could.
We would like to hear from Mr. Justice Harding.
Thank you very much for your time, judges.
Because I've been listening to Mr. Justice Harding since he was a circuit judge. That's how long I've been around him.
And ruled on a number of my cases. Thank you. May it please the court, I'm Major Harding, and I will just take a couple of minutes. I think it's very interesting that the superintendent in their reply brief did not respond to any of the constitutional issues raised in the answer brief of the school board. And are we to take that they concede the constitutional authority of the school board to operate, control, and supervise the schools within the district. I think it's also very interesting that in all of the cases...
I always looked at the constitutional language, and go back to my city days. That's kind of the city manager, city commission kind of relationship, where the city commission, even if they use that language, has the ability to set policy, but the day-to-day decision-making sits with the superintendent. Am I wrong?
No, I don't think you're wrong, and I think that that is adequately expressed in the footnote, and I think that it's interesting in all of these cases, the only reference to the Constitution was in a footnote in the von Steuben case, where it says, we acknowledge that the Florida Constitution gives the school board supervisory powers, but do not agree that limiting the school board to rejection of recommendations and nominations for good cause restricts that constitutional power. And that is something that the school boards agree with. That is something that the school board in Bay County agree with. And of course, in Sperling, they made it clear that good cause was not limited to moral and professional qualifications. It was simply to prevent arbitrary and capricious action by the board. And I think that that case, those cases have clearly set out that that the school board has the authority to operate and control and supervise within the parameters of good cause. And as to good cause, I'm glad a court is making a decision in this case based upon the facts, but I think it would be very difficult for the man and woman in the street to understand that a school board's concern for the student and school performance within the district does not operate as good cause to overrule a decision of a superintendent.
Let me have you answer this question, because I'm a little struggling with this a little bit. I really hadn't thought it out beforehand. Do we even get to the issue of good cause on something like this? Isn't what the Constitution contemplates that the initial recommendation for position has to be by, and I'm sorry for taking so long, but it has to be by the superintendent. And it's only the supervisory control by the school board. And if the school board could not have said, we would like this person to be the principal of Bay High initially, how do they get around to telling the superintendent who has to be principal of Bay High? Because that's what seems to be happening here. What
the superintendent did was make a recommendation or a nomination, and according to the footnote, that is to be done unless, that is to be followed unless the school board finds good cause to reject that, and that is not an invalid restriction on the constitutional power. Thank you.
Counsel, I'm not sure how we'll treat you during this rebuttal phase, but we will not restrict you to just a couple of minutes if you need a little more time.
Yes, sir. Thank you. There are a couple of points I'd like to hit on very quickly. First, in response to Justice Harding's comments on the Constitution, I would note to you that both the Green decision by this court and the Foreman decision by this court, both of those were decided after the Constitution was changed in 1968. The Foreman decision actually quotes from Cherry and once again reiterates that a nomination is final unless the board finds the nominee is morally or professionally disqualified. The Constitution had changed, but the standard did not. Good cause is the same under the old Constitution and under the new Constitution. Also, the Green decision, which very clearly defines and talks about how essential it is for the superintendent to have the ability to determine where people should be put within the school district, was decided in 1984 after the Constitution was changed. Your Honor, the school superintendent clearly under the Goodson case had no authority to enter into a contract relating to the term of employment for Mr. Bollinger. That's very clear case law. Mr. Harrison seems to have conceded that. But I think it's important for this court to understand that the decision of the school board, the collegial decision of the school board, had nothing to do with any promise made by Mr. Bollinger or by the superintendent, Mr. Bollinger. The collegial decision of the school board is set forth in the motion that they all unanimously voted on, and that no amendment was made to. The motion said the reasons for good cause are 1, 2, 3. All voted on unanimously. No one sought to amend it. The sole school board member who even mentioned the agreement, there was only one school board member who even mentioned the agreement. None of the others did. And if you look at the findings of the administrative law judge, and those are at the record at page 479, you'll find that she doesn't mention the agreement.
I always wonder about collegial bodies and statements that are made during the meetings. It really seems to me that while we all know they're probably drafted by their attorney, aren't we kind of stuck with their orders? I mean, their order here said there was at least impliedly said there's an agreement.
Well, if you look, in fact, at the testimony of all of the individual school board members, only one of them mentioned the agreement. Just one. Just one. Not the majority.
But again,
just
collegial body.
That's correct.
You know,
and the case law,
aren't we stuck with their order?
No, Your Honor, you're not, because the case law indicates that maybe they have to state what their reasons were, what their reasons for making good cause were, and that the reasons that they even testified to at the hearing, the majority of the school board had nothing to do with any agreement. Secondly, I want to address the Spurlin decision that Mr. Harrison spent some time on. The Spurlin decision is what they rely upon. In fact, they rely upon a single sentence in the Spurlin decision, second district decision. That case very clearly, in fact, in the opening paragraph of that decision says the reason we're writing this opinion is because we want to clarify some misunderstanding about what we meant, second district meant Von Stevens. The appellee in that case was trying to argue to the court that the Von Stevens case meant you could only look at what's referred to as the 7 deadly sins, but that was the sole list of qualification kind of criteria that you could regard that would constitute good cause. And the Spurlin case said, no. It's not limited to that list. The Spurlin case, just like all the other decisions, just like the first district, just like the Supreme Court, came back and said the school board can look at anything that relates to professional and moral qualifications. So the Spurlin decision didn't change the case law. Nowhere does it suggest it intended to change the case law. In fact, all it was doing was clarifying a misunderstanding about the earlier Von Stevens case.
Counsel, would you address for a moment, please, the response that I got from the school board that if, under the terms of this order approved by the board, the following year, the superintendent did not name Mr. Bollinger to be reappointed, that the school board could reappoint him anyway?
If the final order were affirmed, they could. And that's one of the significant problems with this final order, because they have ordered him, they have taken upon themselves, deemed themselves to have the authority to make that order. And one of the things we argue to you is they have no such authority. Under the statutes of this case, under the case law of this state, absolutely, if there is no recommendation.
Absent the order in this case, would they have had that authority?
No, they clearly do not. If a recommendation is not made as to
well, I guess my concern then is how can the order be valid if it's something that they didn't have the authority to do?
It's not valid, Your Honor. It absolutely is not valid, and that's our whole premise, that this order is replete with reasons why it is not valid. This court must vacate this decision make the decision to vacate the order that's under review because it is erroneous. It's erroneous on any number of grounds. I leave you with just the thought that this is an instance in which the school board has tried to second-guess the superintendent's decision about where administrators should be placed within the district. This court has clearly said they may not do that. That is the authority of the superintendent and not the school board. Thank you.
Thank you very much. Our final case